Government continues to enact retrogressive laws and policies which are meant to shield an imperial presidency from scrutiny, civil society has warned. Hailed as a progressive constitution after its enactment in 1995, there are fears that the term limit and age limit constitutional amendments eviscerated the basic structure of the grand norm. In addition, legal experts and civil society opine that in light of the enactment of draconian laws such as the NGO Act of 2016, the Computer Misuse Act 2011, the Interception of Communications Act 2010, and the Public Order Management Act 2013, a picture emerges of an increasingly restrictive political environment which seeks to reverse democratic gains. Political historians claim that Uganda continues to be haunted by the spectre of its turbulent past, as chaotic scenes at Parliament in 2017 during the age limit debate bore parallels with the Milton Obote pigeonhole constitution, Uganda's first cardinal constitutional sin, which was passed through the barrel of a gun. Daniel Ruhweza, a constitutional law lecturer at Makerere University, opines that the term limit and age limit provisions violated the basic structure doctrine.
The argument there is that you have specific provisions in the Constitution that are so critical. They are like the pillars that hold the house, called the Constitution. And if you tamper with them, then the house may continue in existence, but you have compromised the essence. And some have argued even basically fundamentally changed the Constitution. Much as it may still be seen in its document form, the spirit behind constitutionalism, which is about individuals, you and I, participating by our custom, tradition, our ways of life on how we need to be governed, has been compromised. All right? So, for example, one of the arguments has been that when you change term limits, you've changed something fundamental in our constitutional order.
Dan Wandera Ogalo, a lawyer who was a Constituent Assembly delegate, recalls how a break with the turbulent past informed the spirit within which the 1995 Constitution was framed.
So you can see from all our history, we have never had a peaceful change. So it worked on us in the Constituent Assembly, and we said, how do we ensure that this does not happen? Because when it happens, it comes with a lot of suffering, killings, death, loss of property. So we said, what do we put in this constitution to ensure that we have a peaceful transfer of power? That's how we ended up with a 2-term limit. Said every president, 2 terms. Whether you are good, whether you have done what, in order for us to run away from our history. 2 terms. We put it there. Maybe the mistake we made was not to ensure that we protect that provision by what we call in law entrenchment. We ought to have entrenched that provision to require that in order to change it, you need a referendum. Take it to the people. Because all this violence affects the people. So that one, we should have entrenched it, not only through a referendum, we ought even have required 3/4 of district councils to pass resolutions supporting it before you pass it. We didn't, and it was easily changed by Parliament.
Delays by the executive to enact the recommendations of the Supreme Court in light of judgments delivered in the 2001, 2006, and 2016 presidential election petitions stoke fears that there is a deliberate attempt to skew the playing field in favor of the incumbent. Specifically, the Supreme Court, enriched by the amicus curiae submissions from Makerere University law lecturers, directed the government to introduce 10 recommendations to improve the credibility of the elections. Amongst the reforms sought is to increase the number of days provided for a presidential election petition from 30 days to 60 days, to accept the use of oral evidence alongside affidavit evidence. Government officials and organs who violate laws in regard to access to state-owned media should be sanctioned. Election-related reforms should be enacted within the first 2 years of a new parliament, and laws be enacted to prevent candidates, including the president, from doling out donations during campaigns, amongst others. A shrinking civic space notwithstanding, civil society has contributed to efforts to restore the constitutional order, particularly in the manner in which elections are managed. The Citizen Compact for Free and Fair Elections was one such vehicle, rolled out in 2014. It recommended that a new independent and impartial electoral commission be established. The selection of commissioners and the electoral commission staff must follow a process of open application, public hearings, and scrutiny conducted by the Judicial Service Commission. It also recommended that the military should have no involvement whatsoever in the electoral process and should remain focused on its constitutional duty of securing our borders and defending the country's sovereignty, and a mechanism must be established to monitor and prevent raids for funds from the central bank, ministries and international assistance accounts in the period before and during election campaigns. Further, it recommended that the President should relinquish tactical command and control of the armed forces to the Joint Chiefs and must not serve as the chairperson of the UPDF High Command. A recent study on militarization of the police undertaken by the network of public interest lawyers discovered that the military capture, largely responsible for enacting political policing, has resulted into egregious human rights abuses in the areas of crowd management and riot control. The November 2020 riots in Kampala shortly after the presidential candidate Bobi Wine was arrested in Luka district is instructive. Job Kija, a civil society activist, facilitated the Citizen Compact effort and reveals its motivations.
Almost every election that has happened in this country has actually been challenged by different groups of the political arena. Now, what we felt needed to be done was that Uganda as a country needed to get into some sort of conversation which would help us arrive at an agreeable mechanism, or a new mechanism actually for managing elections and conducting elections in the country. We needed to build consensus.
Ruhweza says whereas reforms are important, there must be a genuine attempt at truth-telling and reconciliation.
You could return the term limits. You could actually even return the age limits. But that does not answer other fundamental questions that deal with things such as biases that people may have, grievances that people may have, pent-up anger, people who have been arrested and have allegedly not returned. You don't know where they are. Those kind of conversations that you hear even in Parliament. You see, we need that kind of conversation where people air out their grievances, and those who can answer can be able to be called to book to answer for those. You take responsibility, and together we forge the way forward.
During the plenary held on 24th October 2023, Justice and Constitutional Affairs Minister Norbert Mao spoke of the need for national reconciliation.
Our country is hurting. Our country needs reconciliation. Not reconciliation between two people, but reconciliation between the building blocks that make Uganda. If you are lost, you go back to a familiar place. Those of us who took long to come to Kampala, we knew, for instance, the post office. So if you got lost, you ask, where is the post office? Even if that's not where you are going. But at least you are sure that from the post office, you can find your way. So let's go back to the Constitution.
In the absence of safeguards such as term limits, Ogallo fears that the country is gravitating towards the cliff.
It is unfortunate because we thought we had made a break with the violent past in 1995 when we made the Constitution. We have failed the country again.
Kija argues that the litmus test is whether government will live up to its promise to deliver electoral reforms that don't favor the incumbent.
It is my hope and prayer that as Chairman Mao and I think the Law Reform Commission have been talking about a constitutional amendment which is likely to come. It's our hope and prayer that the compact is actually revisited, okay, and the critical elements that were proposed in that compact are considered as this electoral, this constitutional amendment is happening.
Almost 2 years to the next general election, constitutional amendments and electoral law reforms are yet to be tabled in Parliament. Traditionally, amendments of this nature from government have not lived up to the expectations of progressives. However, with the opposition in Parliament having embarked on consultations on constitutional and electoral reforms in June this year, there is a sense that patience with the government's constitutional review process is wearing thin. Uganda's checkered history, characterized by a departure from constitutionalism and a total breakdown of the rule of law, continues to cast a long shadow over today's political context. This much was evident to the framers of the 1995 Constitution, who sought to break with the past and worded the document as such. However, subsequent amendments to the Constitution mean that a complete break from the dark past remains elusive. The supremacy of the Constitution needs to be entrenched by a collective effort of civil society, political actors, religious and cultural leaders, and every citizen.